Number 115435, State of Kansas v. Matthew Wilson.
May it please the court, counsel. My name is Carl Maughan. I represent the appellant, Matthew Wilson. Your Honor, I'd like to reserve 4 minutes for rebuttal.
4 minutes is granted.
Thank you, Your Honor. Your Honor, this is an appeal from the defendant's motion to withdraw his plea to 1 count of first-degree premeditated murder, 2 counts of attempted first-degree murder, and 2 counts of aggravated battery. Procedurally, back in April 2013, several people were at a party in an apartment in Riley County. As some of them left, the defendant came out from an apartment across the hall and started shooting at them. He told some of the young women that were there that he was not going to kill them, but he was here for the guys. And then he proceeded to shoot his way into the apartment where the party had been held. One of the residents of the apartment was back in a back bedroom with his girlfriend and her child. When he heard the shots, he retrieved a handgun, and when his roommate tried to enter the room, the occupant then believed that this was the shooter coming into the bedroom and shot twice, striking his roommate and killing him. The defendant later entered a plea, and as indicated above, and was sentenced to life in prison plus 310 months. So it was a plea to a first-degree premeditated murder, so life without possibility of parole until 25 years plus 310 months. Subsequently, the defendant filed a motion to withdraw his plea. The district court denied that motion without granting the defendant a hearing in which he could be present, and this appeal follows. Your Honor, what this comes down to is the factual basis in this case on the premeditated murder charge as it was given to the court doesn't include any indication, any factual basis that all of the elements were met. The element that the defendant did in fact kill another human being was not met. The factual basis was that there was some shots fired and that an individual died. The actual facts of the case are that the defendant did not in fact kill anyone. First-degree premeditated murder requires that a human being is killed, and that killing is done intentionally and with premeditation. We would concede for the purposes of this argument, or for this hearing, that there was a factual basis that the defendant had a premeditation to kill people, and that he intended to kill some people. But the fact is that he did not ever kill anyone, so he failed in his intent to premeditate.
Couldn't we say, counsel, that his acts caused the death of the victim?
Well, yes, so there's the transferred intent argument there.
Well, I wasn't really going to transferred intent so much as just plain old causation, because the facts are pretty clear and undisputed, which makes this theoretically interesting, I'll put it that way, to kind of discuss these legal concepts. You concede that your client, you concede for purposes of this appeal that your client had premeditation, sure, and you concede that the victim was killed. Yes. And the only argument that I see is that you say your client didn't pull the trigger of the gun that killed him. And so then I guess my question is, given that, does that fact matter when your client set in motion a course of events that directly led to the death of the victim?
I would suggest that it does, and I'd point to the Soto case, which talks about in order to sustain a premeditated murder conviction, we have to show that the defendant did in fact kill someone. And while...
But does that mean, saying the defendant did in fact kill someone, does that mean that the defendant had to pull the trigger? Because I'm just asking you, what's wrong with the explanation that this defendant did in fact kill someone. His premeditated acts directly caused the death of the victim.
My answer to that is that he didn't, in fact, kill somebody. An intervening cause killed somebody.
And an efficient intervening cause is.
Well,
what
the question
you
is that
call it.
on the factual basis, there wasn't even any factual basis as to whether the defendant was still in the apartment at the time that I'm sorry, I'm forgetting the names, but the shooter actually shot his roommate. So there is a question there of the intervening time and how much, was this all at the same time? And those facts were not inserted into the factual basis. So what the court did was accept the plea based on a factual basis that didn't, even if we allow for the defendant's actions caused the shooting, there is some question there as to whether it was a proximate cause or whether there was something intervening in the part. I'm not sure if that answered your question, Justice Johnson.
Yeah.
Okay. You know, on a first-degree murder charge, well, on any case, in order to accept the plea, the court must find a factual basis for each individual element. And again, here we had the defendant killed a human being intentionally with premeditation, but the element here that the defendant actually killed somebody was not present in the factual basis and was not, in fact, the case.
Is that true in any scenario where someone else causes the death, even though the premeditation and intent is present for the accused? In other words, let's say I have an intent to kill someone, but I manipulate someone else to do it.
Okay.
Does that absolve me of the premeditation and intent? And it's much the same. I would set in a chain of events that would cause my premeditation and intent to be satisfied.
And I guess this goes to almost an aiding and abetting or facilitating the death of another type of argument, Justice Rosen. And I would suggest that it doesn't absolve you of those acts. But in order
What's different here?
I'm sorry?
What's different here?
Well, in order for that to, the difference here is that in order to be found guilty of an act that is done by another at my behest, I would have to have the same state of mind as the actual shooter, or as the actual person who did the killing. So if we take the typical aiding and abetting...
Bottom line, Counselor, you're saying that the defendant here did not aid and abet the person defending himself.
Correct.
That under our definition of what aiding and abetting is and the mens rea you have to have, everyone has to have.
Correct.
You're saying this was not an aiding and abetting circumstance.
That's correct.
Isn't that what you're saying?
Yes, Your Honor.
But as I understood Justice Rosen's question, and of course he can clarify, it wasn't an aiding and abetting scenario. Let's just make it more extreme. Let's say an individual holds another person at gunpoint and forces that person to then shoot a third person. And there's no aiding and abetting, is irrelevant. Why isn't that premeditated first-degree murder? The defendant in that hypothetical didn't pull the trigger, didn't directly murder the victim.
But he forced somebody else.
But the causation is there. I mean, we're back to that question of
Correct.
are we allowed to consider these concepts of causation in this scenario?
I think, and thank you for clarifying, but yes, I think that the answer there is you can consider the causation, but the factual basis would have to support that causation. So where we have something where there is no factual basis to show that direct link in causation, I think the factual basis fails.
Why isn't the factual basis present when you initiate an active shooter scenario inside an apartment building? Why isn't that a direct cause, foreseeable, proximate of the death?
Again, it depends on how proximate it is.
Well, under the facts of this case, what breaks the causal link?
Under the facts in this case, given the factual basis that was provided to the court, not necessarily...
Right, given the, I agree, based on the factual predicate for accepting the plea.
What causes the factual basis to fail is a lack of facts to suggest that this was a proximate cause. Meaning, so at some point, if I'm hiding in the bedroom and there's been a shooting earlier in the day or earlier in the evening, and I'm still fearful, and somebody walks in the door and I think, oh my gosh, they're back, and I shoot them. At some point in time, that is no longer proximate to the emergency or the shooting at the time. At some point, that becomes a situation where the intervening cause of the shooter's fear, while he sits in the bedroom, causes a... And I'm not here to blame the individuals in this case.
Right, but that's not the factual predicate that was set forth here, is it?
No, it's not. But and that's what I'm saying. In order for the factual basis to be sustained, there would have to be a showing, and if we look at the wording of the factual statement, that immediately or shortly or after the defendant shot his way into the apartment, that the shooting resulted in the death.
Well, didn't the shooting result from a person fleeing him coming in or being there? I mean, this isn't a deal where he's been gone for a while.
Well,
He's there. He's on the premises. He says he's coming after these men. One of them flees into a bedroom occupied by someone who's taken a defensive position.
and that's unclear to me.
Why is it unclear? I understand that it was certainly less than the most articulate statement of a
Sure.
factual predicate at the actual plea hearing, but that was all kind of cleared up after the fact, and everyone seemed to understand.
Well, I'm not sure everyone did understand. If we go to the second argument, that's not just the factual basis, but whether or not the defendant was properly advised by counsel. Obviously, the defendant files a motion to withdraw the plea, citing some of these issues, and the court simply overrules that motion without granting any hearing to determine whether this question was clear to the defendant. But to answer the question, the initial question, I'm not sure whether it's clear that the victim entered the bedroom in immediate fleeing, or whether there was a break in the action that caused the victim then to think, okay, that there's a lull, I can now break cover and go into the bedroom.
But I didn't understand that to be your initial argument. I understood you to concede that we're not deciding this on mens rea, it's on the actus reus. That he didn't kill anyone. That premeditated first-degree murder requires the killing of a human being. And the only way you get there, if you don't actually kill, is through a responsibility kind of statute, either aiding and abetting or some other theory. And so I don't know that the timing of the fleeing is essential to your argument unless you're making a different argument that I'm understanding.
And I'm not making a different argument. I was responding to Justice Stiegel's and Justice Baya's question. The basis of the argument is the defendant did not do the killing. If the court wishes to look at the causality issue rather than did you in fact kill somebody, then the question of mens rea becomes important. And that's what I was attempting to argue. Justice Baya, did I answer your question fully? Right. I see I'm out of time, Your Honors. I'd ask that the court reverse the district court's decision.
Do we have any more questions? Counsel, we've used a lot of your time with our questions. Do you need 30 seconds to wrap up, or do you think you've made your points?
If I could have 30 seconds, I would just like to also point the court not only to the factual basis argument, but also to the question of the Hill factors of whether or not the defendant made a whether the plea was made fairly, freely, and understandably, or whether he was misled or had ineffective assistance of counsel. Thank you very much.
Thank you, counsel.
Chief Justice, may it please the court, counsel.
Counselor, before you get started, can you explain to me what the purpose of felony murder is and why this isn't a felony murder? That somebody sets in motion a dangerous felony and someone ends up dying as a result of it, even though the perpetrator didn't do the killing? Well, I mean, why isn't this simply a classic case of felony murder?
Well, I asked myself that, and the answer I came up with, because the underlying inherently dangerous felony would be attempted premeditated murder. And I wasn't very artful or articulate in laying out the factual basis at the plea, but there was an affidavit, as I set forth in my argument. There was a 13-page affidavit that was filed with the court that laid out the facts. And the facts were that you had 3 people walk out a door of apartment 9. You had Mr. Wilson, who exited apartment 10, opened fire, striking Miss Kim 3 times. She ran down the stairs. He chases her down the stairs. Says he doesn't want to kill her. He's there for the guys. He goes back upstairs where Lowry has grabbed Ferguson and Malaya and brought them back in the apartment, locked the door. He shoots his way back into the apartment. Dustin Ferguson, who's been shot twice, has jumped out the window. Lowry runs in at some point. We don't know, I don't think we could ever come up with exactly when Lowry ran in, but we know that this was all kind of going on simultaneously when he was headed back into the apartment, that Dustin Ferguson is going out a window. He's trying to get Malaya to exit. The defendant, Lowry's ran in to Solano's room, who in the dark has shot him. He goes in and talks to Malaya and says, "I'm not here to shoot you, I'm here for the boys." He then tries to get into Solano's room. And the body of Lowry is blocking the doorway. So that kind of lays what was going on, and we believe there was premeditation.
Okay, premeditated first-degree murder requires, quite simply, the killing of a human being.
Yes.
And unquestionably, the defendant here did not kill Lowry. Would you agree with that?
No. I would agree he didn't pull the trigger.
Okay, he didn't do the actual killing, and we have to find that he's responsible for the act. Solano killed, under the facts that you're reciting, Solano killed Lowry. What we need to do is hold the defendant legally responsible for Solano's act. I mean, isn't that what we have to do in order to find that premeditated first-degree murder conviction was supported by the facts? And what I am struggling with is the legal basis upon which we hold one person responsible for the actus reus of another person without being an aiding and abetting situation. What is the legal principle and what is the authority? We have an aiding and abetting statute.
Except it wouldn't apply because Solano had a right to defend himself in his own residence.
Precisely.
So he can't commit a crime.
So my question is, what in the law makes one person responsible for another person's act if there isn't an aiding and abetting circumstance?
The cases I cited in my brief and the imputed liability that
Did you cite the case about the police officer who ends up shooting someone responding to a situation?
I don't
about
believe
20 years ago?
I
mean,
did.
Sophone.
Thank you. I think that's correct. That's
Sofa
right.
phone, excuse me.
I did not.
I mean, to me, that sounds fairly analogous to this situation. You have somebody who sets up to defend either himself or someone else or prevent further criminal activity. And somebody gets killed. An innocent person gets killed. That's pretty similar to this, isn't it? And we said that was okay.
I did not read that case,
Okay.
and so I
right.
don't want to pretend to know the facts.
Okay. All right.
And I apologize.
No, that's okay.
The Sanchez case out of California that I cited in my brief, where they, quoting from Gaynor, a case out of Pennsylvania, if an appellant here set in motion the cause which occasioned the death of the deceased, he would be as culpable as if he had done the deed himself. In that case, you have rival gang members shooting at each other, a bystander's killed. And the California court, they talk about transferred intent. There's traditional bad aim where you set out to kill one person, but you kill somebody else, you can transfer intent. And some of these cases reflect the law review article I cited from Professor Robinson, but you're looking at what did Wilson intend? When Wilson exited that apartment, opened fire on 3 people, and then followed Mr. Lowry into Ferguson and Solano's apartment, he had, with premeditation, the intent to kill. And
If 2 co-defendants walk into an apartment, both of them intend to kill the occupant, and one of them shoots and kills, is the other's intent enough to make them guilty without being an aider and abetter, just an imputed intent? Is it enough that I intend to kill someone, and if someone beats me to it, I'm still guilty of first-degree premeditated murder? Is that what you're saying?
not necessarily, because there may be, there's another intervening person, but here you don't have a delay. You have Lowry being pursued into an apartment by Wilson, and Wilson is intending to kill him, along with a few other people. And the Sanchez case did reference the Gaynor case out of the Commonwealth, which I thought may closely resemble at least the mens rea and actus reus of this case, where you had Johnson and Gaynor shooting at each other. It's Johnson's bullet that actually kills the innocent bystander. And the Pennsylvania Supreme Court, in upholding Gaynor's premeditated murder conviction, stated that even though it was Johnson's bullet that killed the person, Gaynor's intent to kill Johnson sufficed, even though it was Johnson's bullet that did the killing. And so there have been other jurisdictions that have allowed for this imputed liability. I think maybe satisfying one of the objective elements, and certainly that's what Solano did.
Was felony murder comparable to ours available in the 4 jurisdictions you're talking about?
I didn't look.
Because I'm looking at the Sofaphone, some sites here, and it's talking about the purpose of felony murder rules to deter those engaged in felonies from killing negligently or accidentally, and relieve the state of the burden of proving premeditation when the victim's death is caused by the killer while committing another felony. And it's the felonious intent rather than the homicidal intent that provides the malice and intent required for a first degree felony murder. And that's all very understandable, and I've always understood that's why we have felony murder. If you're going to set in motion a dangerous situation that results in someone being killed, then you've committed felony murder. But I don't know how we make the leap to then be premeditated first degree murder.
Because I think there's a distinction. When you break into somebody's house to steal or rob them, commit an aggravated burglary, that's an inherently dangerous felony that if someone's killed, it's an unintended crime. It can be an unintended consequence if there's somebody who gets killed under the felony murder statute.
So the difference here is that he intended the specific result that happened. Somebody just beat him to it.
Correct.
That's your argument?
That'd be my argument, that he didn't intend to rob somebody. He didn't intend to inflict a aggravated battery or some kind of other felony assault on somebody. He actually intended to kill, and I think that's what separates it from your felony murder cases to make this a premeditated murder.
Can I ask one of my theoretical questions or hang-ups I have here? And that is, what's the crime of conviction? I mean, is it first-degree murder or is it premeditated first-degree murder?
He was convicted under the premeditated first
Under
degree.
that subsection.
Correct.
But, okay, so what do we do with our repeated statements in case law that that premeditated murder and felony murder are not two separate crimes? There's really only one crime, and it's first-degree murder.
With different penalties.
Is that just wrong?
I'm not going to argue that it's wrong or suggest that it's wrong. And that's one of the.
Well, if it's not wrong, why wouldn't a factual predicate showing felony murder be sufficient to support a first-degree murder conviction?
My underlying felony is, again, attempted premeditated murder.
And if that's the case, if a factual predicate for felony murder is enough to support first degree premeditated, then why do they have different penalties? Why are the sentences different? Don't we have a due process? If you're punished more severely for one crime when a lesser crime is proved, that doesn't seem right, does it?
Well, no, I mean, felony murder, under first degree felony murder, yeah, 20 years. At this time would have been 25 for the premeditated murder, would have parole eligibility. The sentences would have been life either way.
But a lien says that the mandatory minimum is
Correct.
Means something, right?
Correct. Absolutely. I'm not disputing that. It's, there isn't, could I charge him with felony murder of Lowry and attempted premeditated murder? Because attempted premeditated murder would have been the underlying felony.
I understand that in prosecutorial lingo, you talk about charging somebody with first-degree premeditated murder or felony murder, and those are two subsections of the statute. Yep. My question is, isn't it more accurate to say you're charging somebody with first-degree murder and that you have alternative evidentiary ways of proving up that charge?
Yes.
And then my follow-up question is just similar to what
Yes.
Justice Johnson said, which is how can there be different penalties attached to different evidentiary alternatives for proving up one singular crime? I'm just trying to figure out how all this makes sense.
I'm not sure it all does.
Okay.
So,
I mean, it's
so that's what we're going to do now, try to make sense.
because felony murder doesn't require necessarily an intent to kill. It requires, when you look at the mens rea, it requires an intent to commit an inherently dangerous felony. Premeditated murder or second-degree murder require an actual intent to kill. It's not necessarily a component of the alternative of felony murder. Am I making sense?
I don't think it's you. I think it's all the.
And that's one of the,
Decisions.
that was really a struggle in this case is, and when he told Miss Kim, I don't want to kill you, after he shot her 3 times, I'm just here for the guys. And then he tells, have they merged? Have the actus reus and mens rea merged? Is this already an attempted murder, and can't he withdraw his intent later? I always thought these set of facts would be great on a law exam, on the bar exam, but they're real life situations. And when he told, Miss Malaya that he wasn't there to kill her, was it too late? Had he already committed those crimes? I mean, there are a lot of charging issues in this case, and I just felt that there was an intent with premeditation to kill Michael Lowry, where I came down, and that during this course of events that were set in motion by Mr. Wilson, 14 rounds were recovered. When Mr. Lowry was killed, the killing was done with premeditation. Even though it wasn't at Matthew Wilson's hands, the killing was done with premeditation. And that's where I resolved this matter for myself.
Do you have any further presentation for us, counsel?
I would just say that in reviewing the record, I believe that the plea did meet the statutory requirements. I cited the Edgar case. This isn't a situation where the defendant has said he's even innocent. He's alleging a different theory of liability, but we would certainly ask the court to deny Mr. Wilson's requested relief.
Do we have any further questions?
Just to clarify, we didn't have a hearing here where defense counsel testified as to whether he or she, what they told the defendant about, hey, there's no question here, this is a classic case of you have no defense, or whatever. So we don't know that. We don't know what the defense counsel told Mr. Wilson before he pled, do we? I mean, there was no evidentiary hearing.
No, not following there was an appeal to this court on sentencing. When the Supreme Court upheld the sentencing the first time around, it went. So you've reviewed this case just for sentencing, but there was no hearing afterwards, no evidentiary hearing.
On the three factors on withdrawal is what we're talking about.
Okay.
Yeah, we haven't had any evidence on that.
Other than the initial plea where the judge recited, went through and asked the questions.
Any more questions? All right, thank you, counsel.
Your Honor, I know we went a little over. Do I still have my full 4 minutes?
You had reserved 4 minutes, yes.
Thank you. Your Honor, I think that the factual basis that was given at the time of the plea would have been sufficient for a factual basis for felony murder. To answer Justice Stiegel's question of what is the difference here, the fact is the crime is first-degree murder is correct, but the 2 different ways of proving that crime require 2 different sets of elements. And so when we give a factual basis that may prove felony murder or first-degree murder under the felony murder side of the statute and fail to give a factual basis for the first-degree premeditated, the question is whether or not the defendant entered a plea knowingly, willingly, and intelligently. because the factual basis doesn't support the elements to which he was pleading to. So I think that may answer some of these questions. Also, the causation question comes down to the intended action. So Justice Stiegels, I put the gun to your head and I say, go kill that person. That's an intent to coerce you to kill somebody. And just like the intended action, the intentional action of pulling the trigger, that is not necessarily the case here. The defendant had no control over the actions and therefore did not intend the actions of Mr. Solano. So what we have here is a situation where the plea colloquy supported different elements than the crime to which Mr. Mr. Wilson was given notice that he had to defend against. And I think that's the major problem here. If I could talk to the transferred intent issue, the Sanchez case and the other case, Pennsylvania. These situations where you have, obviously the bad aim is a different thing. There's still an intent and a premeditation to kill. On the shootout or dueling scenario, both actors still have the same state of mind. They both intend to kill someone, and they both premeditate to kill. So those cases out of California and Pennsylvania, and I'm not sure whether they have a felony murder statute that would support the case like we do here, but I would suggest that the reason why that doesn't apply in this case is because even under those scenarios, both those actors still have identical mens rea. They both intend to kill and they both premeditate.
As an act, and an actus reus, that they intentionally pulled the trigger and discharged a round towards someone.
Correct.
Here we have no act of placing, of firing a weapon.
And that's what the elements of first degree premeditated murder require, is the defendant killed somebody. The other causation scenarios fall under the felony murder, and the legislature has divided those so that we don't have to consider those law school type of questions. Your Honor, was there a question over Karen? No. Sorry. Judge, again, I'd just like to point to those three factors. If the elements, in the factual basis did not include the elements of first degree premeditated murder, there was no objection to it. The defendant didn't seem to know that that was erroneous in any way. It brings to mind the effectiveness of the advice given to the defendant, and at the very least, the district court ought to have convened a hearing on the defendant's motion to withdraw the plea where the defendant could be present and the evidence submitted. So, Your Honors, I would ask that the court reverse the district court's decision. I thank you for your time. If there's no further questions.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement. That